The stickers were ugly. I'll give Pat that much. 6 fluorescent orange markers zip-tied and adhesive stuck across my fence posts weren't exactly what I'd envisioned when I bought this place, but I hadn't put them there for decoration. A Delaware County judge had ordered them there as part of an active property dispute working its way through the Ohio court system. And when I walked outside that Tuesday morning in February with my coffee and found every single one of them gone, I didn't panic. I walked straight to my garage, pulled up the security footage, and watched Patricia Holloway tear them off one by one while talking on her phone, dropping them into a plastic Kroger bag like they were just litter. She had no idea what she'd just done. I'm not a dramatic person. Ask anyone who knows me and they'll say the same thing. Dan Kowalski doesn't overreact. Dan Kowalski reads the documentation first. Dan Kowalski measures twice and cuts once, in work and in life. 24 years as a licensed civil engineer in Ohio will do that to a person. You spend enough time watching buildings go up wrong because somebody skipped a step or ignored a spec sheet. You develop a certain religion about doing things correctly and in order. That's not a personality flaw. That's survival. I was 52 years old that February, 2 years into what I generously called semi-retirement.
I'd left Meridian Structural Consulting in 2021 after a buyout offer that made more financial sense than I could argue with. And Sandra and I had settled into a rhythm I honestly hadn't expected to enjoy as much as I did. She still taught 10th grade English at Olentangy Liberty High School, mornings early and evenings full of grading papers at the kitchen table while I made dinner. I'd taken on a few consulting contracts here and there and spent most of my time working on the property itself.
We'd bought the house in 2013, a 3-bedroom colonial built in 1994. Nothing architecturally remarkable, but the 2 8-acre lot in Harlan Township, Delaware County, was what sold me. Most homes in Stonebridge Creek subdivision sat on half-acre lots, the kind where you can hear your neighbor's television through the wall in summer. Ours was the second largest in the development, a corner of the original 40-acre farm parcel carved up in 1992 when the developer platted the subdivision. We paid $287,000. By 2023, comparable properties were selling north of $415,000. What I put stock in wasn't the appreciation. It was the survey I'd commissioned when we bought it and the deed I'd read word for word before signing anything. The lot to our west, 4318 Stonebridge Creek Drive, had sold in 2019 to a man named Gregory Taft, a contractor out of Worthington, mid-40s, built like someone who'd actually swung a hammer for a living before moving into project management. He built a spec home, finished in 2021, and for 8 months we were fine. Civil waves over the fence, conversations about weather, and the creek flooding in spring. The problem started in spring 2022, when Greg ran a utility trench for a secondary electrical service to a detached garage. The trench was dug using a survey stakeout. His excavator had apparently eyeballed rather than precisely measured. It ran 6 feet over the surveyed property line onto my land, under the area where I'd been planning to build my workshop for 6 years. 18 inches deep, 14 feet long, carrying a 200-amp feeder line for Greg's garage. Under my property, without an easement, without permission, without a conversation. I found it in April 2022 when I hit the conduit with the blade of my Bobcat S650 while grading. I called Greg before I called anyone else. Walked over, knocked on his door, showed him photographs. He thought I was wrong about the property line. I told him I had a survey from 2013 that said otherwise. We each got new surveys done by independent licensed surveyors and compared results. His came back May 18th, mine came back May 22nd. They disagreed by 11 feet at the contested point, the discrepancy tracing back to an ambiguity in the original 1992 plat description, a typo in a bearing call that had gone unnoticed for 30 years because nobody had needed to locate that specific boundary precisely until Greg Taft dug a trench through it. By July 2022, we were in Delaware County Common Pleas Court, case number 22CV 1847, Kowalski v. Taft, boundary dispute and encroachment claim. Judge Carolyn Merritt presiding. Marcus Webb, my attorney, 44 years old, former assistant prosecutor turned real estate litigator, told me from the start that patience would be required. "We're looking at 12 to 18 months minimum," he said from behind his desk on East Broad Street in Columbus. In October 2022, as part of the pretrial evidence preservation process, Judge Merritt ordered that the disputed boundary zone be physically marked. Journal entry 47 required placement of court-designated survey markers at 6 specific coordinates along the disputed line, along with fluorescent orange legal notice stickers affixed to existing fence posts within the zone. Each one bore a case number, a court seal, and language stating plainly that the area was subject to active litigation and that removal or disturbance of the markers constituted a violation of court order subject to sanctions under Ohio Rule of Civil Procedure 45 and Ohio Revised Code Section 292132. Each sticker carried a QR code linking directly to the case docket on the Delaware County Clerk of Court's website. Robert Kearney, a licensed court-appointed surveyor from Lewis Center, placed all 6 markers on October 14, 2022. I was there. I watched him work. I photographed each marker being placed, time-stamped, and GPS tagged. The text printed across the top of each one read in bold black letters, "Court ordered, do not remove, Delaware County Common Pleas Court." These were not my stickers. Not decorative markers I put up myself, not protest signs. They were court-ordered legal instruments placed by a court-appointed professional, their removal explicitly prohibited by law. I didn't love the way they looked either, but I understood what they were. Patricia Holloway had lived at 4401 Stonebridge Creek Drive since 2009 and served as HOA president since January 2020. I'd known her for years. In the early days, we'd been perfectly cordial. She was organized, detail-oriented, passionate about property values and subdivision appearance. What changed, and what a growing number of residents had started noticing, was the particular edge that had crept into her enforcement style since she became president. Pat was 58, 5'4", silver-streaked hair always perfectly styled, driving a 2021 Lexus RX 350 in eminent white pearl. She'd spent 22 years as an HR director at an insurance company in Dublin and brought that procedural authority into everything she did as HOA president. She knew the CCRs by heart. She quoted them in casual conversation. She cited section numbers the way other people cite scripture. What I learned later, and what explains a lot without excusing any of it, was that Pat had gone through a brutal divorce in 2018. Her ex-husband got the house they'd owned in Powell, and she'd moved into Stonebridge Creek with very little of what she'd built over 20 years of marriage. The control she exercised over the HOA, the meticulous attention to every fence height and paint color, was her way of building something that was unambiguously hers. I'm not saying that to be generous to her. I'm saying it because the full story requires the full person. She'd sent me 4 violation notices in 14 months. January 2022, my garden shed color. The CC&R's specified outbuildings must match the primary residence within 3 shades on the Sherwin-Williams spectrum. My house was iron ore, SW 7069. My shed was peppercorn, SW 7024. 3 shades, exactly 3 shades. I sent a written response with both paint chips attached. She sent back a second notice saying her interpretation meant closer than 3 shades. I didn't repaint. I filed the correspondence. April 2022. My trash bins. Their direction when stored in the approved screened enclosure. Pat alleged the bin lids were visible from Stonebridge Creek Drive at a 30-degree angle from the intersection with Millbrook Lane, 140 feet from my property. I measured it. I photographed it. You couldn't see my bin lids unless you were standing at a precise angle, deliberately looking for them. I filed that response too. September 2022, 3 weeks after the court markers were placed. Grass height. Sandra's pollinator garden in the back quarter of the lot, native grasses and coneflowers and black-eyed Susans, explicitly permitted under a 2019 amendment to the CC&Rs for lots larger than 1.5 acres. My lot was 8 acres. The amendment was in black and white filed. The fourth notice, dated January 15th, 2023, was about the markers themselves. Pat didn't call them court markers. She called them unauthorized attachments to common boundary structures, aesthetic violations constituting visual nuisance under Section 7, 4B of the CC&Rs. The notice demanded their removal within 30 days or $150 per day in fines. I read that at the kitchen table while Sandra made tea and felt something shift in my chest. Not anger exactly, something colder and more deliberate. I called Marcus the next morning and read the notice word for word. There was a pause. "She's demanding removal of court-ordered markers," he said. "That's what it says. Dan, does she know what those markers are?" I thought about the text printed in bold on each one, the QR code, the case number in 3/4-inch type. Either she doesn't know, I said, or she doesn't care. Both of those are problems, but one is considerably worse. I wrote a response myself before consulting Marcus on the wording. Certified mail, January 19, 2023. The letter explained clearly and without hostility that the markers were court-ordered legal instruments placed pursuant to journal entry number 47 in Delaware County case number 22CV-1847, that their presence was mandatory under order of Judge Carolyn Merritt, and that their removal by any party other than court-authorized personnel would constitute a violation of state law and federal obstruction statutes. I included a copy of the journal entry, Cherney's placement documentation, Marcus's business card, and the case docket number. Delivery confirmation showed it was signed for at Pat's address on January 21st at 11:47 in the morning. On February 7, 2023, at 8:23 in the morning, Patricia Holloway drove her white Lexus down Stonebridge Creek Drive, parked on the shoulder in front of my property, and methodically removed all 6 court-ordered markers with a plastic grocery bag. She was on her phone the entire time. The whole process took 11 minutes and 40 seconds. My Ring camera on the garage captured it from 60 feet with clear facial identification. My Arlo Pro on the back corner captured her up close on the last 2 markers near the creek drainage, including audio, including clearly and unambiguously her own voice. "They're hideous, Donna. I don't care what he says. They make the whole street look like a construction zone." I watched that footage 3 times before I called Marcus. Sat on a cold plastic stool in the garage with my coffee going cold, watching 11 minutes and 40 seconds repeat on my laptop. Sandra came to find me around 9, keys in hand, ready for school. She looked at the screen, she looked at me. "Is that Pat?" "Yes. Those are the court markers." "Yes." She sat beside me and watched it through once without speaking. When it ended, she said, very quietly, "Dan, do you understand what just happened?" "Yes, I think I do." She touched my arm. "Call Marcus." I called at 9:15. He was already at his office, second cup of coffee, halfway through his morning case reviews. I told him what I had, described the footage in detail before sending it. "Send me everything," he said, "both cameras, full resolution, unedited, the certified mail documentation with delivery confirmation, everything from the court file, all 6 placement photos from Cherney. I have all of it organized since October." A pause. "Dan, this isn't a CC&R dispute anymore. What she did this morning is a crime. Multiple crimes, potentially. We need to be methodical, and we cannot afford anything that looks retaliatory. Can you do that? That's the only way I know how to do anything." He almost laughed. "Good. Don't touch those posts. Don't replace anything. Don't contact Pat. Don't post anything on social media. Just send me the footage and sit tight." I sent everything by noon. While I waited, I did what engineers do when processing something difficult. I went back to first principles and pulled up the Ohio Revised Code. Marcus had mentioned the relevant statutes, but I wanted to understand them myself. Ohio Revised Code, Section 2921, 32, obstructing justice. No person shall destroy, conceal, or alter any evidence in an active proceeding with purpose to hinder discovery, apprehension, or prosecution. Court-ordered markers qualify as evidence. The order's text said so explicitly. Ohio Revised Code, Section 290907, criminal mischief. No person shall knowingly move, deface, damage, destroy, or otherwise improperly tamper with the property of another. Those markers were court property. My fence posts they'd been attached to were mine. Ohio Revised Code Chapter 5312 governs planned community associations. Section 5312 11 prohibits boards and officers from taking actions that interfere with the legal rights of property owners or with proceedings before courts of competent jurisdiction. Plain language. Marcus called back at 3. He'd watched the footage, and the professional calm he usually kept was momentarily gone. "The audio from the Arlo camera," he said. "You can hear her clearly. She says they're hideous. I don't care what he says. That's documented, time-stamped, recorded intent to remove items she'd been explicitly notified were court-ordered. 16 days after she signed for your certified letter." He took a breath. "We need to file for criminal contempt of court, and we need to notify Judge Merritt's office today." We met at his office the next morning, Sandra and I both. I brought a manila folder with printed copies of everything. Marcus laid out the strategy on the whiteboard behind his desk. 3 parallel tracks, he said. First, motion for contempt filed in Case 22 CV 1847. Judge Merritt can sanction Pat personally, mandate fines, refer for prosecution, or impose jail time. She takes order violations seriously. Second, I'm contacting the Delaware County Sheriff's Department to file a police report for criminal mischief under ORC 2909-07 and obstruction of justice under ORC 2921. 32. Third, I'm writing a formal letter to the entire HOA board advising them that their president has committed a criminal act during the exercise of her duties, and that the board has potential institutional liability under ORC Chapter 5312 unless they take immediate corrective action. He turned from the whiteboard. The HOA track is your best near-term leverage because the board members have personal exposure. Most don't carry directors' and officers' insurance, and even those that do have exclusions for intentional criminal acts. Every board member is looking at potential personal liability. They will not want that. Sandra asked what Pat faced if it went to criminal charges. Marcus said criminal mischief was a third-degree misdemeanor, up to 60 days and $500. Obstruction of justice was a fifth-degree felony, up to 12 months and $2,500. Contempt carried its own separate sanctions. The footage was the kind of evidence that makes prosecutors pay attention. "What do we want to happen?" Sandra said. "I wasn't interested in putting Pat Holloway in prison. I wanted 3 things: markers replaced and protected, the boundary case undamaged by their removal, and the harassment stopped permanently. I want the markers replaced at her expense," I said. "A formal apology from the board, the 4 violation notices withdrawn, and her off the board." Marcus filed the contempt motion on February 10th. By February 13th, I had text messages from 4 neighbors. Harold Briggs, 71 years old, retired civil engineer, the man who'd warned me about Pat 3 years earlier, was first. "Dan, heard something is happening with Pat. You need anything, you know where I am." Lisa Garraway at 4209 sent 2 words. Finally, Tom Szymanski at 4319 sent something carefully neutral that I read as him figuring out whose side to be on. The 4th text was from a number I didn't have saved. When I replied, the response came back. "Denise Cho, I'm on the HOA board. Could we talk privately?" I called Denise that evening from my back porch in the February cold. She was 39, a software project manager in Dublin, 2 years on the board. She sounded like someone who'd rehearsed what she wanted to say but wasn't sure how it would land. "I received a letter from your attorney today," she said. "The whole board did." "Okay, I need you to understand something. I didn't know those stickers were court-ordered. That information wasn't shared with the board before the notice was issued. Pat handles a lot of compliance actions herself without bringing them to a full vote." "I see. And I didn't know she'd removed them herself. I found that out this morning." A pause. "I'm genuinely sorry this happened, Dan." I chose my next words carefully. "Denise, I appreciate you calling, but I can't have this conversation in any substantive way without my attorney present. I know, I just needed you to know that not everyone on this board knew what was happening."
"That's useful information," I said. "Thank you."
I relayed the conversation to Marcus verbatim the next morning. He was quiet for a moment. "She's worried about personal liability. The question is whether she's willing to act on that worry. She might be our path to a board resolution that doesn't require full litigation. I filed the police report at the Delaware County Sheriff's Office on February 14th. Sandra came with me. The deputy who took my report, Officer Reyes, late 20s, listened with careful professional attention. She asked good questions about the certified mail delivery, the audio from the Arlo footage, whether I'd had any contact with Pat since the incident. When I set a USB drive on her desk with all the digital files, she raised an eyebrow. "You prepared this in advance." "I'm an engineer," I said. "Documentation is a reflex." The criminal charges were referred to the county prosecutor's office on February 21st. 9 days later, Prosecutor David Henshaw called Marcus directly. He'd looked at everything and come to a quick conclusion. Marcus quoted him directly in our debrief. "This is either the clearest obstruction case I've seen in 5 years, or it's the most preventable, and I can't tell which is worse." Henshaw was issuing a criminal summons for Patricia Holloway on 1 count of criminal mischief and 1 count of obstructing justice, 5th-degree felony. That was March 2nd. The contempt hearing before Judge Merritt was scheduled for March 15th. I didn't tell the neighborhood about the criminal charges before the hearing. What I did do was post a calm, factual single-page summary to the Stonebridge Creek Facebook group on March 7th, no editorializing. Just a timeline with document references and a link to the public court docket. The post got 43 comments in the first 2 hours. Most were supportive. A few defended Pat. One, from Dave Kellerman at 4-88, said, "If you'd just taken the ugly stickers down like the HOA asked, none of this would have happened. I didn't respond to that." Sandra very much wanted to. She didn't either. We had a brief dinner conversation involving language I won't repeat here. On March 8th, Denise Cho and Barry Fenton, 2 of the 4 HOA board members, sent a joint letter to Pat placing her administrative authority on hold pending the outcome of the court proceedings. CC'd to Marcus, 2 of her 4 board members had just turned on her. Marcus told me Pat had called him directly on March 9th. She'd asked whether there was any way to resolve the matter before the hearing. He'd told her I was willing to discuss a resolution that included specific terms, markers replaced at her expense, formal written apology from the board, withdrawal of the 4 violation notices, and her immediate resignation from the board. She'd gone quiet for several seconds. Then she said, "He wants me to resign." "Yes," Marcus had said. "I've given 6 years to this neighborhood. I understand that, Ms. Holloway. But you removed court-ordered legal markers from his property 16 days after receiving written documentation of what they were. That has consequences. I need to think about it." The hearing is March 15th. That's your timeline. The week between that conversation and the hearing was the worst stretch of the whole ordeal. Not because I doubted the case. The documentation was airtight. The criminal charges were filed, but the waiting has its own weight. Sandra was watching me carefully, checking in at dinner in the specific way she does when she's concerned, but doesn't want to make it worse by showing it. I wasn't sleeping well. Not from fear, exactly. From the relentlessness of it. 18 months of surveying and filing and documenting and responding, and now everything sitting in a manila folder waiting for a courtroom. I'd lost 7 pounds since the dispute started. My shoulder hurt from tension I'd never felt before. On the night of March 13th, I went out to the fence line after dark with a flashlight. You could still see the adhesive residue on 3 of the posts where the markers had been. I stood there in the cold and thought about what this piece of ground represented. Not just in dollar terms or legal terms, the simple, specific sense of having paid for something and worked for something and planned for something for years, and having someone treat it as though your rights were subject to their aesthetic preferences. There's something in that particular injustice, small and large at the same time, that I think is at the root of why stories like this resonate. It's not just about property. It's about whether you get to exist on your own terms in the space you've earned. I went back inside and made sure all my documents were in order for the 15th. The morning of March 15th was 23 degrees, and still, Sandra kissed me at the door and said, "Come home with good news." I told her I'd come home with accurate news, which made her laugh, which was exactly the right way to leave. Delaware County Common Pleas Court sits on North Sandusky Street in Delaware, Ohio, a county seat of about 40,000 people with a proper town square and a hardware store that's been there since the 60s. The courthouse is solid limestone, built in an era when institutions were supposed to project permanence. Marcus met me in the lobby at 8:15. "She's here," he said. "And her attorney, Whitaker, he's competent. He knows his client has a problem." We found a quiet corner in the hallway. Marcus kept his voice low. "Whitaker called me at 7 this morning. Pat will accept 3 of the 4 terms: marker replacement, withdrawal of the violation notices, formal board apology. She's fighting the resignation." "That's not enough." "I know," I told him the same. He argued resignation was beyond what the contempt proceeding requires. He's technically right. The judge won't order her to resign. Resignation isn't a judicial remedy. "So what do we do?" Marcus was quiet for a moment. "Take the 3 terms, add a substantial financial penalty, covering Cerny's replacement work at $2,400, my fees at $8,500, and a binding written agreement that any future interference with court-ordered instruments constitutes a permanent waiver of all HOA authority over your property. And I want a written acknowledgement, signed and notarized, that she received your January letter, understood the markers were court-ordered, and removed them anyway." "That acknowledgement is a confession," I said. "I know. What about the resignation?" He looked at me steadily. "Sometimes the process produces the outcome without requiring the specific remedy. If she's facing a contempt finding and a felony obstruction charge, the board may make the resignation happen themselves. Denise's letter last week suggested they're already moving that direction." I thought about Sandra's question in his office. What do we want to happen? I thought about the fence posts with adhesive residue. I thought about 18 months of certified mail and county clerk offices and nights I couldn't sleep. "Tell Whitaker we'll settle on those terms," I said, "but I want that written acknowledgement, every material fact admitted in writing. I'll be right back." The negotiation took 22 minutes. I stood in the courthouse hallway and drank terrible courthouse coffee and watched the ordinary business of human conflict being processed into legal outcomes. Marcus came back at 9:03. She agreed all terms, including the acknowledgement. Total financial settlement is $11,400. He paused. "The criminal charges are David Henshaw's. We have no authority to dismiss them. Pat knows that. That train left the station." We went into the courtroom at 9:15. Judge Carolyn Merritt was exactly as I remembered from the boundary case hearings. 62 years old, silver-haired, with the measured deliberateness of a judge who'd seen enough manufactured urgency to be permanently unimpressed by it. She reviewed the settlement, asked 3 specific questions about the acknowledgement language, the replacement timeline, and the criminal proceeding status, then looked up. "Mr. Whitaker, your client understands this settlement does not affect the criminal charges currently filed with the prosecutor's office." Whitaker stood. "She does, Your Honor. And your client understands that should similar conduct occur in the future, any interference with court-ordered instruments in Case 22 CV 1847 or any related proceeding, the court will treat that as direct and willful contempt, and the outcome will not be settlement eligible." "She does, Your Honor." Judge Merritt looked at Pat for a long moment. Pat sat at the defense table in a burgundy blazer, hands folded, looking at a spot somewhere between the bench and the middle distance. She looked smaller than she did driving her Lexus. She looked like someone who finally understood the distance between what she'd thought she was doing and what she'd actually done. "Settlement accepted," Judge Merritt said. "Replacement markers placed within 15 calendar days. Financial terms fulfilled within 30. The written acknowledgement filed with this court as a supplement to the case record." She set down the papers. "We're adjourned." 12 seconds, 18 months of work, and the formal moment of resolution took 12 seconds. I sat there after the gavel and just breathed. Marcus leaned over quietly. "Good outcome." "Yeah," I said. Robert Cerny came back March 22nd and replaced all 6 markers. Same fluorescent orange, same legal text, same QR codes. I stood in the cold morning air and watched a professional do precise, careful work. I didn't take photographs this time. Marcus did. The markers were still ugly. I didn't care even a little. The $11,400 check arrived at Marcus's office on April 3rd, 13 days before the deadline. He sent me a scan with a one-line email. Cleared. I printed it and added it to the manila folder. Patricia Holloway resigned from the HOA board on March 28th, 2 weeks after the settlement. The resignation letter, read at an emergency board meeting attended by 46 of the subdivision's 112 homeowners, cited personal and health reasons and thanked the community for 6 years of service. Denise Cho was unanimously elected interim president. Her first major action was commissioning a full legal review of the CC&Rs by a Columbus area HOA specialist. The review cost $3,200 and produced 23 specific amendments, including an explicit prohibition on interference with ongoing legal proceedings affecting member properties and a requirement that any enforcement action involving legal instruments be reviewed by board counsel before issuance. I attended that meeting. Sat in the back row of the Stonebridge Creek clubhouse. Harold Briggs sat next to me. He didn't say anything when Denise read Pat's resignation letter. He just folded his hands in his lap and nodded once, very slightly, the way you nod when something you've been waiting for finally happens. The criminal case concluded on May 14, 2023. Patricia Holloway entered a no-contest plea to the criminal mischief charge. The obstruction of justice felony was reduced to a fourth-degree misdemeanor as part of a plea agreement. She received a $750 fine, 12 months unsupervised probation, and 40 hours of community service. No jail time. Whether that was the right outcome from a criminal justice standpoint, I genuinely don't know. What I know is there's a public record of what she did and why she did it. That record is permanent. The boundary case, Kowalski v. Taft, resolved in September 2023, Greg Taft purchased a recorded easement for the utility conduit at $14,500, reflecting market value of comparable easements in Delaware County. The conduit stayed in place. My property line was confirmed by a third agreed-upon survey. I broke ground on the workshop in April 2024. A 28 by 40-foot detached building, concrete slab, insulated walls, a 100-amp electrical service of my own, designed to the inch by me personally. Sandra has already claimed the east corner for a potting bench. I told her that was negotiable. She told me it wasn't. We've been married 26 years. I know which negotiations I can win. Harold came over last November and stood in the middle of the foundation outline while I was grading. Said without preamble, "You know what you should have done differently?" I stopped the bobcat. "What's that?" He considered it. "Nothing. I can't think of a thing." He pointed at the foundation. "That's a serious workshop then. Quieter. She's in Westerville now." He'd heard through the neighborhood network that Pat had sold her house and moved to a condo closer to her daughter. "Fresh start, I suppose." "I hope so," I said, and I meant it. Not with sentiment exactly, but with the plain sincerity of someone who'd spent a year and a half looking at the full picture of another person. The good, the flawed, the understandable, and the inexcusable, and arrived at something that wasn't quite forgiveness and wasn't quite indifference, but was somewhere in the honest middle. She'd done something wrong with full knowledge and faced proportionate consequences. That's what the system is supposed to do. That it actually did felt, in this particular instance, like something close to grace. The markers are still there, still fluorescent orange, still ugly, still unmistakably official. They'll come down when the easement is formally recorded and the case concluded. Then the fence line will just be a fence line, and the steel survey monument will just be a piece of metal in the ground, and probably nobody walking past will ever know there was a story behind any of it. I've been thinking a lot about the difference between what something looks like and what it actually is, about how often those two things get confused, and what happens when someone in a position of authority decides that what they see is more important than what's actually there. The markers looked like litter to Pat. They looked like an offense against the order she'd spent 6 years building. They didn't look like what they were, which was the physical manifestation of a legal process that exists to protect the property rights of people exactly like her, and exactly like me, and exactly like every other homeowner in Stonebridge Creek, regardless of what they think of each other's paint colors. She saw ugly stickers. She removed ugly stickers. She had no idea those ugly stickers were holding the whole situation together. The documented, court-sanctioned, legally protected markers that said, "This matters. This is real. This is being watched by people with authority." Once you decide your aesthetic judgment supersedes the legal framework that exists precisely to prevent people from acting solely on their own judgment, you've lost something more important than you know. The ugly things we want to remove because they're inconvenient or don't fit the picture we have of how things should look. Sometimes the ugly thing is load-bearing. Sometimes it's doing a job you didn't bother to ask about before you tore it off the wall. The morning I finished pouring the workshop slab, I walked the full perimeter of the 8 acres with my coffee. Early April, cold still, but with that first tentative edge of Ohio spring. Sandra's pollinator garden was showing the first signs of life. The creek corridor was running clear. The survey monuments were where they were supposed to be. I stood at the corner stake for a minute. The fluorescent orange markers caught the early light. Ugly as ever, I finished my coffee and went back to work. So if you've ever had to fight for something you knew was yours, against someone who had just enough authority to make that fight expensive and exhausting, I'd genuinely like to hear about it. What did you do? And looking back, what would you have done differently? Leave it in the comments. I read every one.